We had very short break. Did you really have a good break? Okay. Now the time in Korea is 3:50 p.m. And I'm sure that the many in the foreign countries would have very late time in the evening. And thanks to your passion and dedication, we have also been joined by a lot of the participants from different countries around the world. And I really hope that everyone has already joined for the second session, about the 200 participants. For the second session, the title is The Role of the State in Adoption. And for the session 2, we are going to join the two speakers. Throughout the presentations from the two speakers, they're going to deliver their ideas on the role of the state in adoption. And please keep the time in 20 minutes for each presentation for the session 2. Q&A will be also held after the session 2. For this session, we are also going to invite the Janina as the moderator for the session 2. The first speaker will be Kang Jung-eun for this session.
Welcome back. Thank you. For adoptees, information that could lead to finding family is available only at the discretion of a caseworker who might be moved to help with a search. Although the 2012 revision to the special adoption law sought to give adoptees access to their birth records and regulate the search process, deliberate misinterpretations of the law mean that records are still not fully accessible. In other words, an adoptee might get lucky, but that might not be the case for the next person. Our next two speakers in session 2 will analyze the role of the state in adoption. They will discuss the international legal frameworks that could be used to correct unjust practices and better ensure an adoptee's human rights, including records access. They will also highlight limitations of the existing child rights conventions and the current Korean law. So I think I heard that our next speaker is Kang Jung-eun. And Kang Jung-eun is a lawyer with the nonprofit Duru Association for Public Interest Law. At Duru, the law is used as a tool to advocate for the rights and interests of children. In addition to adoption, Ms. Kang is engaged in activities related to birth registration, children in prison, juvenile justice, child abuse, child sexual exploitation, child participation rights, and student human rights. Her presentation, titled Current State of the Adoption System and Working to Ensure the Best Interests of the Child, will look at why adoption is a child rights issue. She will review the current legal system, focusing on the domestic legal system and international human rights norms. She will then examine the current state of the implementation of international human rights norms in Korea and outline future tasks.
Let me start my presentation. I'm from a non-profit organization called Duru. I am lawyer. My name is Kang Jung-eun. Adoption is the method for the search, the original families. And I think that it's also the way to seek the best interest for the rights of children. And now we are seeing that for the sake of the finding the fundamental rights of the children is definitely essential and crucial. I also believe that I am here to highlight the importance and essential factors including the protection and advocacy for the children's rights. And I think that for the interest of the children's rights, I'm going to present. Okay, let me move to the next slide. This is the contents, adoption and the rights of the children. And based on the domestic as well as international, the standards and the rights for the children, let me also reflect upon those status as well as the future challenges. Still, we are seeing that the prominent challenges in terms of the overseas adoption. So as of the 2019, unfortunately, we are seeing the very high numbers, 317 in terms of the overseas adoption and more than 380 in the domestic adoption. You're also seeing that the table here is specifying that the percentage between domestic and overseas adoption. Absolutely, it's fundamentally supported by the government to provide the circumstances and the conditions in which the children are to be reared by their original families. And out of the 232 in the U.S., we are seeing that the percentage 73.2% in terms of the overseas adoption from Korea. And as you can see here, still definitely we are seeing the direct connection between adoption and the rights of children here. First of all, still the child are entitled to know their identity, the root. Of course, the next speaker will be also deliver the relevant issues and the topics here. And still, according to the professor, Alice Diber, we also need to absolutely include and incorporate all the information from the root and their identity from their birth. Absolutely, they are entitled to know their name, nationality, and their natural family as well as their natural parents as well. They also need to entitled to know the rights of the pursuing the happiness as well as they are to be respected in terms of their dignity and their values as a human. And now we also need to look at a lot of the responsibilities and the obligations. Especially, we also need to identify and specify the roles and responsibilities of the government in protecting and advocating the rights and interests of the children. And we also need to reflect all the different principles, including the non-discrimination principles as well. So in accordance with the Constitution of Korea, this states that the children are definitely to be entitled to have their independent personality. There should not be the target of the training or the protection. And this also stipulates that they are entitled to know and to have their dignity and the pursuit of the rights of pursuing their happiness until they become adults. And according to the Article 10, all citizens of Korea are to enrich their dignity and their values as a human being. And the nation should absolutely provide the obligations in guaranteeing and checking the humans, irreversible, the human rights for all the individuals. So currently, you can also see that the dualization between the special adoption law and the civil law. According to the Article 3, the children needing the care are to be also included under the special adoption law here. And this law also has the effect of the children born to a married couple. In accordance with the civil law, there are some regulations for the adoption by the intervention as well as the general adoption, the measures here. And can you see that a lot of the services and the relevant authorities related to the processes of overseas adoption in accordance with the Constitution of the Korea as well as the special adoption law here. According to the Article 7 of the UN Convention on the Rights of the Children, absolutely all children's their records and their birth records should be registered immediately upon their birth, including their names and their nationality and their natural parents. And according to Article 21 of the UN Convention, adoption of children are to be fundamentally the tangible and the reasonable and trustworthy according to the applicable law and the procedures. And the relevant authorities can also decide based on the regulations as specified here. And for the overseas adoption, absolutely, the reasonable processes and methods can be considered if the nation of the birth on the adoptee cannot provide the circumstances for the child rearing in that condition. And also, the Article 14 by the UN, the Commission on the Rights of the Children, also prioritize the main task and the responsibilities in protecting the rights of the children here. And I think that all the elements are to be considered as not the priorities, but absolutely utmost the necessary the factors and the fundamental rights for children here. And according to the law, every steps and every procedures are to be stipulated and verified according to the international human rights standard here. And in terms of the identity of adoptees and children, they also need to be protected, including the information of birth parents as well. So, the ways in protecting their original family and any circumstances in making some separation between the children, adoptees, and their original families are to be really carefully considered. In terms of the overseas adoption, in other words, the Republic of Korea have not come up with the specifying the clear standards and criteria in regulating overseas adoption. In accordance with the Hague International Convention on Adoption and the Children, the state, the principles, including in guaranteeing the human rights and the rights of the children, as well as the post-adoption services as well. And I'd like to also share some of the ideas to know the history and the background of overseas adoption here. For Korea to implement the relevant regulations, the special law on orphans and adoption have been revised and enacted since 1961. And since 2012, the permission, the law, and the acts were introduced under the control of the family court. And probably the next speakers will be also deliver the relevant ideas here. And still, this is one of the very prominent issues, which is the falsification of the records of orphans here. And still, absolutely, we have come up with very good ideas in the making very simplified the procedures from the point of the adoption and also to the approval by the natural families for the adoption. Next is proxy adoption. In accordance with the special law on orphans adoption, according to the Article 6, the foreigners are be able to get the proxy adoptions in accordance with the adoption procedures by the relevant authorities and the organizations here. And we can also see that there have been a lot of impairments from the past in enforcing those regulations. And still, we have seen some difficulties, which is the absence of the post-adoption services on the services, especially in the area of the overseas adoption. Still, we have seen some of the increasing numbers of the child abuse among their adoptive families. And there are a lot of the lack of the monitoring and the tracking records after their adoption. As of August 2017, the number whose identity and the nationality have not been fully checked was over 25,000 people. And the rights for adoptees to know their identity have been strongly infringed. And still, we are very lack of the information to verify and to prove their identities due to the very limited number of the records and the information. And since 2019, unfortunately, we have also seen the percentage in which the government was rejected the disclosing the information and the records was over 82.8%. And I believe that the Korean government took the third and the fourth, the final discussion and the dialogue in implementing and enforcing the rights and standards by the UN Commission on the Rights of the Children. And still, we are seeing very invisible the challenges still ahead. So, still, we are seeing a lot of the rukas from the different countries to solve the issue for adoptees altogether. Absolutely, we should get rid of the negative perspectives on the single mothers, and absolutely, we need to put the proactive efforts in the finding out the relevant services for adoptees as well as the single mothers as well. And we also need to guarantee the circumstances in which the adoptees can have their human rights. Next, the activities for the better future. Regarding the future task here, absolutely, we're really looking forward to the more ideas and the more actions from the government for the better future of adoption. Absolutely, not just only the special adoption law and the civil law, all the relevant standards and regulations should be unified. And still, in terms of the processes from the adoption and the post-adoption services, all the processes and the procedures should be strongly and strictly adhere to the relevant standards and regulations, not only just by the adoption agencies, but also by the government as well. So all the stakeholders should come up together to talk about the relevant ideas and seek the solutions. Still, each adoptee are to be guaranteed to know their identity upon their birth. And all the records should be absolutely managed and kept by the government and public organizations. This is not really a matter of the cooperation or coordination. This is the identity in which the human rights, the fundamental human rights, are to be inherited. The government should guarantee and also make the actions in the protecting and implementing the human rights and the rights of the children and adoptees. They also need to establish the database and information to share more ideas and the records. They also need to guarantee the procedures for more research and inspection on keeping the adoption records. Absolutely, the government should reduce the number of the dissolution of adoption. Adoptive parents cannot terminate adoption by themselves upon their request or upon their determination. All the termination procedures should be bilaterally negotiated. And still, in some cases, they also need to comply with the relationships, and they should prohibit any immoral behaviors on their adoptees. Any consultations regarding birth family, birth parents, and all the adoptions, the procedures are to be broadly discussed and consulted. And next, depending on the principles for all the procedures in terms of adoption, all the regulations, including the special adoption law, is to be considered thoroughly. And still, the certain age under the 13 as a child are only to be guaranteed. So we also need to seek the more solutions and ideas in providing more better incentives as well as the circumstances for the adoptees. So these are the roles and responsibilities to be implemented by the NCRC. They absolutely are responsible of monitoring all the procedures of adoption. They also need to comply with the relevant law and the standards as well. And in accordance with the convention as well as the Hague International Adoption Convention, they also need to provide the technical human resources as well as the financial resources as well in fulfilling all the regulations and standards. This, on the Declaration Day, on the Adoption Justice Day, absolutely, these are the challenges that we have to make for the future. Absolutely, we need to spread out more public awareness and the campaigns to know and to increase the more roles of our services. Still, the more governments should be more involved in the providing services and the relevant laws for adoptees as well. Absolutely, continuous and systematic monitoring systems are to be guaranteed according to the current law as well. If we can, absolutely, we need to provide the tangible outcomes for adoptees. So for the citizens, communities, and the nations, as well as the stakeholders around the world, absolutely, if we can make some changes for the better future of the adoptees, we need to come up together to gather more ideas for the better ideas. Let me wrap up my presentation. Thank you.
Thank you. Our next speaker in session 2 is Alice Diver, a senior lecturer in law at Liverpool John Moores University in the UK. A former lawyer, Ms. Diver has lectured in law since 1993. Her research interests lie in adoption law and human rights. She is the author of A Law of Blood Ties, The Right to Access Genetic Ancestry. A Canadian adoptee of Indigenous descent, she is adversely affected by Quebec's veto laws, but reunited with the maternal side of her birth family in 2017 via a DNA search. Her presentation is titled Identity, a human right to ancestry and genetic origin. She writes, human rights law frameworks should, in theory, protect and promote the right to genetic identity. Instead, they fall short by sidelining the needs of origin-deprived persons, permitting adult-centric vetoes on information, sealed records, and gamete donor anonymity to outweigh the best interests of those of us who are denied genetic ancestry and heritage. Ms. Diver.
Thank you. Okay, I'm just going to try and screen share if I can. So
Okay.
Bear with me.
No problem.
And I've got it. Okay.
Great.
My apologies for the technology. And also I logged in under the wrong name because I used my husband's laptop, so hence the delay. I'm apologizing for,
Nope.
oh dear. Okay, so basically, thank you first of all for inviting me. It's been amazing so far to hear everyone's stories, and I feel very privileged as an adoptee to be invited to take part. What I wanted to propose as a question, and I'm very happy to take thoughts and criticisms. I wonder whether if someone is crafting a human right, a claim to genetic ancestry, to receive biological truths and to avoid origin deprivation, are human rights the best way to go about this? That's what I'm asking really. And I call it origin deprivation because I think that term encompasses a lot of the harms that we can suffer as adoptees. It brings in an awful lot of issues and many aspects. In the manuscript, I look more closely at UN guidance and country reports. You'll be glad to know I won't go through those at the talk. They're a bit lengthy, but I will look at some recent case law from the UK, from Ireland, and briefly at Strasbourg Court, because there's mixed messages. There's some good news, there's some bad news. I'll end on a happy note with looking at what the UN is doing with donor children and surrogate born people, because there is some progress, some slow but good progress coming from there. Okay, so basically, if you wanted to craft a rights claim, you could look to socioeconomic aspects, you could look to family life. I'll explain why there's drawbacks with that in a moment. If you wanted to frame your claim as more of a civil political issue, you might want to plead the loss of name and nationality. You might want to look to cultural integrity as well, though I'll come to that in a moment to explain why it's not always ideal either. The older, more fundamental concepts are finding their way into the jurisprudence. So we've got human dignity, which possibly is getting redefined now with the way health issues have gone. Equality and non-discrimination, they too have problems because discrimination can be very easily rendered lawful. I won't get started. And the Children's Convention should hold a lot of hope, but again, I'm going to deal with why it has certain problems and certain issues. Human rights are wonderful on paper, they give hope, they're often beautifully written. By the time they get down to the level of domestic courts, decision makers, the people who hold our birth records and who permit vetoes and don't lift them, by the time the law filters down there, best interests can be so widely defined and so differently defined with a lack of consensus that it can be, I don't want to say next to useless, but it can be quite ineffective. And obviously the Children's Convention, I'm 53 and it doesn't do me a lot of good. I'm still going to get hit by the veto. Didn't find out I was an Indigenous adoptee until I was 21, until I got non-identifying information, which told me I had a nice shaped head, and that was about it. It wasn't really terribly useful, but I won't start. But some good news. There is at least a recognition of the need for psychological integrity. So best interests at least is starting to realize that we do need genetic connection. We need information. One major drawback that I would argue is the Children's Convention. There's no obligation on parents to inform we adoptees of our origin. Donor conceived children are often in the same boat. So that's a bit of a serious flaw. Social stigma, is that still there, associated with infertility, etc.? These are issues that maybe the law simply cannot look to overcome. So this is why I think there's some scope with civil and political rights to maybe try and get around the private family law obstacles. If you do look to civil political matters, if you talk about cultural heritage, you can then bring in issues of having lost ancestral lands, having lost tribal lands, things like language, religious belief, various things that go into culture. Again, word of warning with the experience of Indigenous peoples. Problem with pleading cultural heritage, we so often tie that to land and to land-based property rights and aspects. I'm thinking of the Halibut Band in Newfoundland. I'm thinking of their experience. if you leave the land for work, it's nearly like victim blaming. It's, oh, you turned your back on your culture deliberately, and that's going on at the moment. I would say, what about, like myself, the child who's conceived into one jurisdiction, into one culture, but is then born in another, adopted in another, and maybe is never told. So yeah, there are issues there. And I will talk closer to the end briefly about the Paradiso and Italy case, where statelessness was seen to really impact catastrophically on the child's family life, and I would say best interests as well. But it's an upsetting case, so I'll keep it to near the end as a special treat. It's worth looking, before I leave the Children's Convention, to underscore how much wording matters and how much the attitude of drafters and decision makers matters. When this was 30 years ago, but when it was being drafted, some of the working group had issues even with the very concept and term of family identity. Others wanted protections to only be attached to the families that are recognized by law. Well, thank you for that, but if you're born out of wedlock like myself, then you're not going to be related in law, and that takes away your genetic connection. So it's a bit of a legal fiction that is annoying. They also were very reluctant to bring in birthkin repatriation. I guess repatriation makes us think of land and reconnection and things that cost money. That's going to be costly. It should happen, but I see that will be a difficult one. We know that human rights, they tend to favor negative obligations of do no harm, positive obligations of keep everyone healthy, reunite families, provide funding for contact meetings. These are a bit stickier. We know that. I sound very harsh on human rights, but I'm going to look at the flaws before I get to the good stuff. So what happens if you have a legislative void? What if Parliament is afraid of grasping the nettle, is afraid of, bringing in controversial reforms? Does it fall then to the courts? Yes. What happens at the level of domestic jurisprudence? There's a number of things happening. We get sometimes there are complicated legal gymnastics. So you will have some judges, more so recently, and sometimes it's wonderful to watch, they will tie themselves in knots to produce equitable, compassionate outcomes. And that's some of the case law I'm going to share with you now shortly. And although I'm looking to surrogacy at the moment, because that seems to be where things are happening, but a lot of surrogate children are adopted as well. And I would argue they have the same issues as ourselves in terms of getting an accurate birth certificate, finding ancestors, making contact with their ancestry. And there's a lot of really lovely things angry material being written at the moment. Those who write about surrogacy, they're quite blunt, and rightly so. They will say, look around you at the human trafficking. Is this womb leasing? Is it reproductive brothels? So if any of the sources that I'm mentioning, please feel free to email me, and I can send you the link, or I should have the article somewhere. And arguably, are we reduced to property law? Those of us who have been commissioned to cure infertility. It's a harsh way of looking at it, but I'll come back to property law at the very end to say that possibly that's another way of trying to get the system to help us. So there was a recent case in Ireland that I want to share with you, just to illustrate how ineffective the law can be and the fear that attaches to change. This was a case of two sisters, one of whom was a surrogate for the other, and they used the egg of the other sister to produce the child, all altruistic and went very well. When they came to register the child's birth, they said, I'm the mother, it was my egg, I'm the genetic mother, I'm adopting the child, my sister carried the baby. Registrar said, how lovely, great, registered the accurate situation, was overturned, and the Supreme Court said, no, we can't change the law. The law says legally the mother is she who carries the child, and this is a matter for Parliament. So that's rumbling on. I take it that maybe they couldn't have done very much, but what a missed opportunity. But it's a case worth reading, and it just shows how law is limping behind technology. Thank God for technology. I wouldn't be in partial reunion. A couple of English cases that I've chosen because I really like the discourses. One from 2014, and the court actually pointed out there's painful legal confusion, that it's not ideal to not know your genetic ancestors. And they said, please, can you reflect for the child's benefit? Can you, give us some accuracy and some legal truth here? And they look into adulthood. So they're acknowledging that these are issues that can affect you throughout your life. That was repeated again a couple of years later. Then they talk about lifelong security. This was a child, the law changed, as it can do, where a surrogate conceived child was being brought in. And because the law changed overnight, they became stateless, and it did get sorted out, but the courts were rightly appalled and said, look at lifelong security and welfare. They talked a little bit about relatedness, but no one wants to go there, to really grasp that nettle on genetic relatedness. I like this case from 2018, the Z case. The courts basically said, parents, fertility clinics, please listen up. You need to stop with the administrative falsehoods. They didn't say you're telling lies, but that's a phrase I'm going to use now, administrative falsehoods. This is relevant for those of us, I think, who are hit by vetoes, donor anonymity. They're talking about the potential position of the child who might yet be born, which is quite forward thinking. And they talk about the medical, social, emotional reasons that we seek out truth. It's not just idle curiosity, there's a need to know. So that was a quite gratifying case. The Supreme Court also had a case that made me, well, in a limited way, slightly happy. It's a sad case. The father, genetic and legal, he decided when the child was born to disappear, to relinquish parenthood. And the court got angry and they said, no, whether you like it or not, you're part of this child's identity and background, genetically, legally. We can't force you to parent, but you can't deny the genetic reality. It's not a perfect case because they seem to forget there was an anonymous egg donor, 50% of the child's genetic ancestry. Adoption did resolve the matter to an extent. This is the bit that gave me hope. I wonder, was the judge adopted? The court said the adoptive mother is an adoptee herself, and therefore she's going to understand the sensitivity and understanding that's needed. She will be aware of the issues. And I thought, fair point, thank you. It was nice just to have that acknowledgement that we do need a bit of extra protection. Now, this is the case that will make you angry. You've probably heard of it. It made the headlines. Tragic case of a baby boy being brought in, was conceived in a Russian fertility clinic, brought back into Italy when he was 8 months old. And because Italian law does not look kindly on commercial surrogacy, it's illegal. So the authorities took umbrage. Basically, it was dealt with as a criminal matter. The child was very swiftly removed to an orphanage, a children's home, spent another year and a half there before going to strangers. No contact with his adoptive parents. And the court said that 8 months is not long enough to build up family life rights under Article 8 of the European Convention. I would say if you're an 8-month-old child, that's your entire life. And I'm stunned for all the wrong reasons by this case. Parents had thought there was a genetic connection. There was some mix up at the clinic, so there was no genetic connection. This mattered possibly much more than it should have. Now, I've been calling for decades for genetic connection to matter. Be careful what you wish for, because in this case, the genetic connection mattered because it was absent. Had it been there, I think the child would have stayed with the parents, but the court really, it's not how I wanted them to acknowledge the importance of genetic connection by, doing this on a child. And Article 8, family life rights were therefore not affected. So there's no violation. So what a waste of an opportunity, what a dreadful case. There's a lot written on it. It has sparked discussion and some righteous anger, which I suppose is something. If you're interested in it, it's worth reading French cases that came beforehand, similar facts, completely different outcome. These were American surrogate clinics that were used. And yeah, it's very interesting to see how the court dances around the issue and ignores what it said beforehand. And it goes to the margin of appreciation. It's, courts are the domestic courts are free to interpret human rights the way that they wish. But yeah, I mean, there was discrimination there. I see no other way of analyzing it. They merged procedural and substantive matters, which isn't good. So we await to see what can happen next. And I love, Eliadu has pointed out, they said they've almost created a new form of family, an illegitimate family. That's not ideal. It's just further stigma. Okay, what else can I tell you? Yeah, that completely undermined identity, reality, and legal and social aspects. And I think it's fair to say that the sidelining still occurs there. Property law principles, at the very, very end, I'll return back to. You'll find in a number of UK domestic cases that they talk about consent, the contract, the ownership of genetic material in terms of parental rights. So yeah, property law creeps in. I don't know if that's always terribly, say that as a property lawyer and a human rights lawyer, it's not always helpful. But I'll conclude on reasons to be hopeful. There are good messages, good things are coming out of the surrogacy realm, in that parentage is at last being recognized as a matter of international concern. Now it's tragedies that are throwing it into the spotlight, but whatever works to give us a greater voice. The limping parentage concept is getting mentioned again and again. So it's where a child is in limbo. They've not yet achieved a legal parent, and that can happen. And the dangers of that have also been highlighted. And deliberate orphanization, legal fictions, these are words that need to be said. And the law maybe needs to be embarrassed if it looks over and sees what the scientists are doing. So we've got DNA, thank God, DNA matches occurring and families being reunited. And the law's over here somewhere ignoring that, saying, oh, really? So it's worth looking at the Hague Conference from last year. They are talking about a new convention, which will help bring greater recognition to the decisions of foreign courts. And maybe a protocol will come in. We don't know. They've left out inter-country adoption. They specifically said, oh, there's enough law for that. I don't know how I feel about that. They do at least say, and that's something, they at least say that a number of important issues and challenges still attach to domestic adoption policy. So we've not been totally excluded. And I think we can hopefully transplant some of the wisdom that's emerging. It's not a priority, but at least they haven't forgotten us. Recommendations, heartening recommendations have come in from one NGO. The UN actually sat down and took direct testimony. I know they do this, but I like this one, from support group for donor conceived children. And they accepted formal recommendations. I like this one in particular. Here's one of the recommendations they're taking on board. Here's why it's significant. Comprehensive and complete records of all parties involved in the conception of the child should be held by the state in perpetuity for future generations. I like that. Perpetuity makes me think land law and trusts and equitable concepts. Future generations, I think there's an implicit recognition of harm there, and I think that marks a little bit of progress. And adoptees as well, we can only, I think, but benefit from that they, if it has to be via our vulnerability, I'm okay with that. I think anything that can lift a veto and that can get us our rights. Because as I say, Quebec veto, I still can't get a birth certificate. My birth mother has offered to go in to where the records are kept, and say, we're in reunion, give us all our paperwork. And she feels guilty for putting on the veto, but such is life. Oh, thank God for for science. Now I'm open to challenge. Please feel free to, to argue with me and to ask questions, but I'll end there. I hope I haven't gone over time. I probably have. I'll apologize if so. And thank you for listening. Share.
Thank you very much for your great presentation, the two speakers for the second session. I'd like to also give a very big round of applause from my mind as presented by the lawyer Kang. And the number of the overseas, the adoptees, was about the 317, and about 100% was actually from unwed mothers. This was one of the very shocking news to me. And I thought about this issue. And now the time in Korea, and probably for some of you have started joining our conference from 1 o'clock. And now we have been going through a lot of the long hours for the conference today. Once again, thank you very much for your great participation. And now, for the third session, the moderator will be the lawyer Hwang from 공감 Human Rights Law Foundation. And let me also introduce the panelists as well. So moderator for the panel discussion will be also the lawyer Hwang. And each panelist will deliver their presentation within 7 minutes. Please keep the time within 7 minutes for each panelist for your presentation. And for those of you who have signed the registration in advance, if you log in the web link, all the documents and the reports for today's conference are available on the website. So if you'd like to deliver and if you'd like to share any documents and have a look at them, please log in the website so that you can download them. So all together, we will also have the overall panel discussion at the end of the session 3, after that, attended by all the presenters and speakers from session 1 and 2. I am the moderator, Hwang. For the panel discussion, we are going to listen to some ideas and issues from scholars and academia as well. And this is the panel discussion for the session 3. And we have also listened to a lot of the information and presentations from adoptees as well as the scholars as well. In terms of the research and investigation for the rights of adoptees and the children, let me also introduce about their speakers. So, all together, we have the 5 panelists working for the non-profit organization, the one from the government of Korea, and the one has been the scholar who has researched for a long time in the relevant area here. So first panelist will be Hala Taru. She is the president of the 325 Karma, the Korean branch, and she'll be delivering her presentation. And thanks to her, a lot of the dedication and the research, she'd like to deliver her presentation.
Thank you. Hello from Denmark. I've been listening in from early morning here. First of all, I want to thank all the other speakers on speaking on such important matters and very emotional matters. I also want to thank everyone for making this possible today, and I'm happy to be joining here online. So I will simply start my presentation. I will be talking about the importance of DNA testing that other speakers already been talking about today already. Birth family search as well. I will make only a short introduction of myself. My name is Helle Torup. I'm a Korean adoptee, and I was adopted to Denmark when I was around 3 months old. In 2017, I decided to move to Korea to get involved in the Korean adoptee community. I was hoping to get to know different organizations on ground that helps other adoptees. In 2018, I started working for 325 Camera. 325 Camera is a non-profit organization. The acronym CAMERA was recently changed from Korean American Mixed Race Adoptees to Korean adoptees making reunions attainable, to make it more inclusive to Korean adoptee community. The mission of the NPO is to distribute DNA kits to Korean adoptees and Korean birth families worldwide. We want to reunite Korean families when possible and also help pass on important medical and family history from birth families to adoptees when reunion is not possible. We provide DNA kits from a DNA testing company called Family Tree DNA and distribute them for free of charge, which is made possible by a donation from T&W Foundation via Thomas Park Clement. When I became familiar with 325 Camera, it was the first time that I heard about DNA testing related to birth family search. Not having factual information on my own adoption records that can help me find family was one of the reasons why I got involved and why it makes sense for me to do this kind of work. I'm here today to talk about birth family search, the importance of DNA testing when searching for family, and our experience with adoptee cases, records, and identity. For adoptees who have records with information, they can apply through their adoption agency or the NCRC to get access to parts of their records. The agency or NCRC will initiate a search if there is information on the birth family. Some adoptees are able to locate and reunite with birth families. For many other adoptees, this is not a possibility. The amount of information shared during the time of adoption is often only partial information sent by the agency. Many adoptees experience getting more information and sometimes very different information when going to their adoption agency in Korea. Some adoptees have two sets of records, one that is manufactured and one record that contains that correct information. At the time of the adoption, the adopted parents are often given only the manufactured one. Later on, the adoptee might get access to the correct record. Some adoptees have to show up several times at their agency in order to gain more information. In terms of records, one can also never really rely on the information given due to many factors. These records have been proven to be falsified, manipulated, switched, or simply non-existent. I've seen cases where adoptees are not able to obtain the family registry at their local community center. They're told that they are not registered. This is actually a necessary step in order to complete an adoption. Every child born in Korea needs to be registered on a family registry. There are cases where there is actual information on both ends for the adoptee and the birth family. The adoption agencies don't initiate contact unless the other party had asked to open the case. The search must be initiated from both sides before the agency will begin contact and connect the family, which means that if birth parents go to the agency and ask to reach out to the child, it is only if the adoptee has already reached out to the agency that they will initiate contact. This sometimes applies the other way around too. We know of one case where an adoptee, Robin Joy Park, had been reunited with a person through her biological person she thought was her biological family for 5 years. She later found out through DNA testing that her records had been those of an adoptee who was at the same orphanage. It was a similar story for Diane Boshe Liam, which is explained and portrayed in her documentary In the Matter of Cha Jong-hee. The identity of Cha Jong-hee was given to Diane after the girl's father changed his mind at the last minute, and Diane was sent to the States within a couple of days. A social worker at the agency decided that the adoptive couple in the States would never know the difference, even though they had gotten to know Cha Jung-hee through pictures and letters. In another case, where an adoptee's identity was switched with another child's, the identity of a child who died in an orphanage was given to someone else. Still today, this adoptee has not been able to receive any information from her original records through the adoption agency. We know of at least 11 more cases where records have been switched. DNA testing as a last resort. When there are no leads in records or when a case leads nowhere, DNA testing is often used as a last resort. For some adoptees and birth families, this is the only way for them to search for each other. DNA testing is also important for confirming the relationship between adoptee and birth family. The different tests that are used, here are a couple of examples. One-to-one tests are those used in the Korean forensic database. I will explain that later on. Autosomal DNA tests identify unknown living and recently deceased relatives within 2 generations. Autosomal tests are used by 3 to 5 camera through the DNA testing company Family Tree DNA. Using autosomal tests, we have had success in matching adoptees with distant cousins, finding birth families by building family trees and doing more DNA testing. This is not possible when you DNA test with the police or Daogene. DNA tests used in Korea, such as Daogene or the one used by the Korean National Police Agency via forensic services, will only show direct matches, such as mother, father, and siblings. These tests cannot define if there is a distant relationship that goes beyond the birth father, mother, a full sibling. The test will say there is no family match, but perhaps the sibling is a half sibling or it's an aunt instead of a mother. Kara Boss's case, which was handled by Daogene, is one example. She wrote on Facebook, quote, "I received a negative test result with my half-niece last summer when I tested a Daogene. However, a 3 to 5 camera result came in a couple of weeks later with a positive test, and this was validated in April with my father testing at SNU. Daogene even told my half-niece last summer that there was almost 0% chance that we were not related, which proved to be not true," end quote. Furthermore, the National Forensic Database for Missing Persons Family is only available for adoptees with no records of birth family or for birth families who have lost family member. If you have information on your birth family, such as names and birth dates, or if you have been relinquished by your birth family for adoption, it is not easy and often not possible to submit your DNA to this database. There are many steps to follow that must be all exhausted before relinquished adoptees or adoptees with information in the records can test this way. The decision is made based on the adoptee's records, which might contain wrong or falsified information. Autosomal DNA test does not require these steps. Records and identity. For Korean adoptees, records and identity are closely linked, and what is often on the record is often the only information about their past that they know. Scant and incomplete information means scant and incomplete knowledge of their beginnings in life. This is a big part of a person's identity and perhaps the only evidence of their existence. Adoptees cling to these pieces as the only link to themselves and their country of birth, without knowing whether the information given is true or not. The number of adoptees seeking to do birth family search speaks for itself. The need is there, but the resources to help adoptees are not, and this is what we wish to change.
예, 발표
Thank you.
감사합니다. 그 다음에는 친가족
Thank you for your presentation. Next presenter is Dave Leap, who is the birth family search mentor of Goal. and an overseas adoptee of USA. For the past years, he has been dealing with many birth family searches, and he can probably share with you very realistic stories.
Okay, thank you for the introduction. Thank you for hosting this event. Due to time constraints, I'll kind of cut my story a little bit short here. So as was introduced, I've been working with Goal for about a year now, actually over a year, in their family search department. And because of this position, I've been in a unique position to where I get to see and assist in hundreds of family search cases at all various stages of the process. And commonly it starts from a point of confusion. There's a lot of people that just don't know where to begin, what's possible, what's not possible, which agencies are involved. So we like to kind of go ahead and give some basic information on how to start the search process. Oftentimes there's a lot of frustration because if they have already contacted a relevant agency, there will be long delays in responses, so they don't know what to do. So I think this kind of speaks to a wider issue as far as just the lack of information, but also misinformation and the lack of trust in information that has already been given, quite often due to anecdotal cases that are presented. So from my perspective as a fellow adoptee who's been able to assist other adoptees with their family search, I found that withheld documentation, accuracy of information, and the lack of data tracking of information are kind of the common obstacles when searching. But as an organization, we want to educate adoptees about how the process works and what are kind of the current limitations, as has been kind of discussed by previous speakers due to the current laws within Korea as far as the rights to search and origin records. So by now, I would like to just comment that it's quite well understood within the adoptee community that all abandonment cases that were truly, not all abandonment cases were truly abandonments. There's numerous stories out there where you can hear that someone was listed as an orphan and abandoned, but then later when a search had happened, somehow they were miraculously able to find parents, meaning the adoption agencies. So we know that there are documents that exist in adoptees' files that are not accessible to the adoptee themselves. So oftentimes we often say that there's basically an English-facing document, and then there's the document copy for the agencies. And currently within the restrictions of the laws, those documents are not accessible to the adoptees. And even if these documents could assist in a search, it's just not possible for us to get access to those documents. So with that being said, currently there's no real way for the adoptee to know if they were ever truly abandoned in this case, since they won't have access to those documents. And since there's not truly a neutral third-party organization that can audit or verify the contents of an adoption file, it's just pretty much impossible at this point. The agencies often claim that the data is private property and has been kind of discussed by other speakers. I think that's something that needs to be challenged. Who actually owns the property of the identifying information within your case file? However, I've reviewed countless cases that similar documents have been released to other adoptees, which can lead to confusion, where some people say I've got access to these documents and other people don't have access. And oftentimes the sensitive data is redacted so as to not to violate Korean privacy laws. Yet some adoptees were still able to obtain certain documents that were told by their adoption agencies that did not exist. So this kind of highlights that there's a major issue of consistency, a lack of consistency of the practices of the adoption agencies. Information regarding the inconsistent practices of record keeping and release of documents is rapidly disseminated through social media that adoptees frequently frequent, and which leads to even greater apprehension and mistrust of the agency's practices. So while some files are not able to be accessed, the files adoptees are able to review can sometimes have misleading or even inaccurate information. There's a case that comes to my mind of recently where we had started to kind of question the accuracy of the information provided because with the assistance of a search, it had mentioned a particular religious organization within a particular town. And when we were able to search on Naver and Google to determine if this place actually existed in this organization, we did find something, but it was not exactly matching with the data. So it just, didn't ring true with what was going on. It was within the same city, but it was just too far away from what was currently recorded. So at this time, there was just no other information, and we were going to send the adoptee to this area, thinking, well, maybe this is a place where they can obtain more information, maybe talk to the people in the area to see if they knew her story. And this search changed after a different organization was able to get full access to the records. And within those full access to the records, there was a kind of a seal, kind of like a stamp that had the religious organization, which directed the search to a totally different area within the same town, but basically not where we were going to send the adoptee. So I think this kind of illustrates how this information that wasn't given to the adoptee, which might not have actually given out anything private that would have been protected by private regulations or private laws in Korea, actually can alter the search potential. And so sometimes how some of the data that may seem trivial to one organization may actually be quite substantial. While this new information and having them go to the location didn't actually directly help them in locating their birth parents, it did have a profound impact on the adoptee. They were able to verify without a doubt that this newly discovered place was a part of their existence and part of their origin. So with all of this in mind, I think it's important to note that it's incredibly difficult to find reliable data supporting the anecdotal cases of mismatched or inaccurate adoption records. Not to say that it didn't happen, it's just hard to find the data. As the adoption agencies have kind of historically acted under a maumdero or as they see fit model of business, this makes it difficult for our community to accurately cite data regarding our origins, our past and present search efforts. So as an organization, we want to work toward providing more context for those involved and their relevant official responsibilities, as this helps empower the adoptee and hopefully gives them some sense of control. This can manifest from simply explaining what the telegrams are that are sent to potential birth parents, but even before that phase of the search process, how contact information was discovered to even attempt contact with a potential birth parent. This is especially relevant as sometimes adoptees are told in their files that they were abandoned. So again, how can they possibly locate a potential birth parent if their records had been told the whole time that they were abandoned without information? But I think it all comes down to what the adoptee hopes to get out of their personal search. In numerous cases that I've worked on within the past year, there's a common theme of wanting to discover anything that is a part of the adoptee's concrete origin and how that can be just as powerful as a natural reunion. In the current landscape of searching, it's difficult to trust the accuracy of records without a neutral and accountable organization managing the records, or at the very least auditing the process of assisting adoptees searching for their birth parents. Our hope is that going forward, adoptees, agencies, and third-party organizations like GOAL can better understand such limitations and wholeheartedly assist each other in this journey.
예, 여러 가지
Thank you for sharing various cases to touch on the major defaults of the current institutions. Next, from Ministry of Health and Welfare, Division of Child Welfare Policy, Administrative Officer Hae Ryung-jo will touch on the problems with adoption records from the position of the Ministry of Health and Welfare's Child Welfare Policy Division. You probably don't know, but
Our communities made endless efforts and revised the special adoption law. And with the help of Ministry of Health and Welfare, we have investigated into various adoption-related issues and their families. So I know that the ministry has made a lot of efforts in this regard. I don't think it's a limitation of the law, but it's more of an interest of support and interest. So I think that we need to actively be engaged in these activities together. So let's invite Ms. Hae-ryung-jo onto the screen. Hello. I am Hae-ryung-ju from the Ministry of Health and Welfare, Division of Child Welfare and Policy.
조금만 크게 볼륨을 크게 해주실래요? 네, 말씀해 보시죠. 예, 들립니다.
Yes, sorry. Yes, we can hear you now. Can you hear me? Yes, you can go on. I work on child welfare policy at the Ministry of Health and Welfare. My name is Hae-ryung-jo. I am very delighted and honored to be here at the first Adoption Truth Day International Conference. Today, I want to look at the problems in adoption records from the position of the Ministry of Health and Welfare's Child Welfare Policy Division. So let me begin. First of all, I want to look at the history of the laws on adoption records. In 1961, the Act on Special Cases Concerning Orphan Adoption has been enacted to promote the human rights of adoptees. There is no article regarding adoption records on this because there was less consideration in the importance of finding the roots of the birth families. Next, in 1977, the special adoption law has been enacted. And in the enforcement rule, you can see that new articles have been established on the storage of adoption records, stipulating that the adoption organizations should retain information and data on adoptees. However, still, there is no stipulation regarding the storage period. Afterwards, in 1996, the Act on Special Cases Concerning the Promotion and Procedure of Adoption has been revised and established a permanent preservation regulation for adoption records, stipulating that as a post-adoption service for adopted children, the documents must be permanently preserved by the adoption agencies. In 2012, the special adoption law, the name changed to special adoption law, and the role was not simply to promote adoption, but to enhance and promote the human rights of the adoptees. And with this new law, there have been changes to many of the articles. You can see here briefly that they established a new regulation for the provision of adoption records and also established a new regulation for the digitization of adoption records and a new regulation for the transfer of adoption records to NCRC when adoption agency closes, and also a new regulation on the right to request the disclosure of the adoption information of adopted persons. You can see the details in the gray box. According to Article 21, you can see that the adoption agency shall provide the NCRC with information on the adopted children and their families, and the adoption agencies can keep records as a digitized form. And the data should be permanently preserved for post-adoption services. Also, the information on adoption, the details of what kind of information is needed is stipulated in the next articles. So the name, resident registration, number, address, contact number of the birth parents, and etc., as well as the birth parents' information, the names, contact number, why they're putting their child up for adoption, and their consent to disclosing information, and the name and information on the adoptive parents as well. So these are important information for the adoptees. And going further, preservation of digitized information, saying that such records should be permanently preserved at the agencies. And in case the agency closes, the information should be migrated and transferred to NCRC. And lastly, regarding the disclosure of information on adoption, the person who has been adopted may request the disclosure of information on his or her adoption held by NCRC or an adoption agency. So, with the first adoption-related law enacted in the 1960s, we've gone through a lot of change and developments, and we're creating a systemized management adoption record. And I believe that we have made good results so far. First is the adoption records computerization project. So, by providing birth family search services based on the establishment of a national system for preserving and managing adoption records, we're ensuring the adoptees' rights to know. So, about 23,000 individual adoption records from 1950s to August 2012 from the adoption agencies have been fully digitized, and afterwards, the adoption agencies directly enter the information into the Central Adoption Information Management System. Also, information held by the child welfare facilities, about 60, excuse me, but can you put the volume up a little bit more? Thank you very much. To maximum, please. So let me continue. And also, documents held by the Ministry of Health and Welfare and the National Archives, about 39 individual documents have been digitized. So we'll continue the digitalization of these records, and also request cooperation from local governments and child welfare facilities that keep the records. Next, I want to touch on the adoption information disclosure system. We introduced this system in 2011, and we now have the foundations for a better system. So persons adopted under the special adoption law are the targets. And you can see here the procedures and the workflow. First, the adoptees either to NCRC or adoption agencies, they can make a request for information disclosure. And they check the address of the birth family and initiate the search. And when the birth family consents to the disclosure, they confirm the consent and then notify the adoptee on the family search progress. And we send the results via mail, and if they don't reply after 3 times of sending mails, we inform them that the birth parents do not consent to the disclosure. Over the past 3 years, these are the results of the system. There have been about 2,000 cases, and 50 to 60% of them have enabled to check and locate the birth parents. But if they refuse to disclose the information, the number goes down. And about 30 to 40% of them have no information or less information, so it is unable to locate the birth parents. So government has been making further efforts in this regard, but we can see that the actual performance is not as good as expected. So we want to further improve and ensure the adoptees' right to know. And at the 20th National Assembly, the member In Sun Nam has introduced a bill to revise the special adoption law. So we have a long history of adoption, and not only the parents but the descendants of the adoptees should be able to have the right to search for relatives beyond what is possible now. Also, the new bill establishes a basis for requesting the phone number or mobile number of the birth parents from the relevant organizations to check whether the biological parents consent to disclose the information. So we want a more accurate and correct information. Also, there are new provisions for obtaining birth parents' consent before adoption information is disclosed. So if they make consent before the disclosed, the process can become more quicker. And lastly is to support DNA testing and counseling for birth family search. And the details are in the gray boxes. And this is the bill is currently up in the National Assembly and is under review. So before the revision of special adoption law, the adoption information has been managed outside of the system. So there was a lot of loss or distortion or manipulation in the information. And as a result, finding the roots for adoptees faced a lot of difficulties. So after 2012, the government now wants to manage this data at the government level and to digitize the information. And even the information from a long time ago, we want to digitize it and manage the information at the government level. So as mentioned earlier, in the previous National Assembly, we wanted to have more accurate information on phone numbers of the birth parents and for consent to disclose adoption information. So in the process of discussion at the National Assembly, I hope we can go to the right direction to further support and promote the human rights of adoptees. So once again, somehow many people have criticized the government's role in issues of records and identity, but we will make further efforts. And once again, thank you to the hosts and organizers for the event. Thank you very much for your attention.
네, 발표 감사드립니다.
Thank you for your presentation.
다음은 로스 오크님.
Next, Ross Oak is the next presenter. He's also an overseas adoptees general manager at Human Rights Beyond Borders. He will talk about the best interests and the rights to origins. He's been doing a lot of research in this area, and he also is involved in another organization as an activist.
Yes, hello. So I submitted a paper, so if people want to read that, they can read that. I'm going to talk a little bit off of that paper, actually based upon what was discussed here and also in the previous presentation, because it seems like there's a certain theme that's coming about. And to start with, let me actually time myself so I'm not going over time here. If we look at for a second, for example, what Professor Driver had been mentioning about, it shows the example of the difficulties of actually turning a lot of these issues that we're dealing with into local or domestic legislation. And this is coming from, if you look at those countries with quite well developed, or I would say relatively better developed records information compared to Korea, which is, as you can see here, not the best at that area. In terms of what the UN can do, based upon my experiences at lobbying and advocacy at that level, not only the UN, but the ACCH, I think one of the issues is the mention of surrogacy, for example, it's an emerging issue. I think about 10 years ago, when they're at that level, the discussions were among different drafters and different scholars and different people trying to figure out what to do. It's sort of like the biggest question was, do we want to create a convention on surrogacy? Because if we create a convention on surrogacy, then we're at the same time legitimizing it, basically. But if we don't create a convention on surrogacy, then people can just do whatever they want. So that was it. So it's been very sort of slow going at first, but I guess as we can see now, there's a lot more information emerging there. And so I think that attitude there was sort of like, at that time, 10 years ago, I would say it's sort of like adoption has sort of, it's old news. People were like, okay, adoption's been in the past. We have to focus on a lot of the, people were looking for new areas to focus on, and surrogacy was sort of like the newest thing here. But so as we're seeing here, and especially too, so I think there's that idea that like, okay, this has already been talked about a lot. But actually, in reality, maybe it's been talked about a lot at the international level, but not a lot has actually been done, because we're still dealing with these issues here at the domestic level in such a poor circumstances, I guess you could say. So if we look at, for example, like the UN, they have done a lot on adoption abuses, especially like I think in 2017, the Special Rapporteur on the Sale of Children actually released reports about the child trafficking and threats going on in intercountry adoption. A lot of that stuff has been at what you want to call the front end of it. So there's been a lot of focus on this whole front end about the adoption abuses going on these days and trying to prevent those, less so actually on what happens after that adoption in terms of records, that kind of stuff. And I think that you can just see that even in like domestic systems, there's sort of like this idea that once the adoption is completed, then it's all over, it's all done with. Having said that though, with intercountry adoption, I think it's a little bit unique in the sense that you have a receiving country. So it's not just everyone wants to sort of beat up on Korea and everything like that, which, yes, the country's responsible. But I think too, at the same time, looking at, for example, we think about, based on some of the organizations I worked with in the past, we have talked with some of the government bodies, like the Anti-Corruption Agency, the Ministry of Health and Welfare, and they have tried to do what they could, but they're limited too at the same time because agencies are private. So there's only so much they can do. And we could say, well, I don't want to say it's all about just legislation issues either. I think at the same time, there's not a huge push either. And I think among us, you can see there's a huge push. But then when we think about it as in terms of the overall mainstream issues going on these days, basically, I feel like adoption stories, at least in Korea especially too, is sort of like these individualized stories. There's like this, not this necessarily vision of this systematic abuses going on. So what I bringing this back when talking about the UN and international bodies and stuff like that, they can play a role in this, but their role will be limited. But at the same time, I don't think that they have been basically leveraged or used enough in a way. So for example, if you have your own, if you're a receiving country, that receiving country also has some responsibility. It's been very difficult to actually get them to be responsible on these issues. But, you know, talking with diplomats from some of those receiving countries, and they were saying is like, you know, if there was if we saw, if, you know, if we were getting information from the central government that we need to focus on this, then we would focus on it. But we haven't really heard much from the central government about this issue. So we're not really pushing Korea on this issue. And so on the domestic level, I think in Korea, it's sort of limited on what can be done with just the community here is quite small. So at the same time, trying to get the international, those adoptees outside too, to sort of push and to make a sort of concentrated effort. How can that be done? This is just discussion right now. So I'm just trying to give some ideas out. So I think in the sense that to even engaging, you know, those receiving countries can be quite difficult because you got to know, well, a government's a very big body composed of different little bodies. So who do you go to? Ministry of Foreign Affairs, Ministry of Health and Welfare? Do you go to the visa people? So, you know, they can all, so basically if they're not talking to each other, then even though if you talk a lot to one body, the other body might not communicate it, so they never hear about it. So I'm trying to show this sort of like this very much fragmented challenge also. So on the one hand, to change legislation, there needs to be sort of like that, okay, push. Why should people change it? But at the same time, too, is if there's not sort of like that external push to change anything, then most likely it's not going to be pushed that much. And I think, too, one of the other challenges that we can see is there are, to get those receiving countries to sort of push, they need evidence. But of course, then that creates another whole sort of difficulty is like, how can you get evidence if you don't have access to the file? So what I'm just trying to sort of talk about here is just sort of highlight some of the difficulties and things. So at the moment, there's not a lot of answers right now, but it's just sort of like to sort of bring in these issues that we're facing, and then maybe people can sort of more discuss about it and everything. So thank you.
Thank you very much. We have also mentioned that what types of these systems and the procedures are needed for the further development. And the last speaker for the panel discussion is Professor Kim Ik-hwan from the Graduate School of Record Information in Myeongji University. And he has the expertise in the managing the archive system, even though we have not really worked with him for a long time. So he will going to talk about how to establish the archive and the fields of adoption. So let's listen to his presentation.
Good afternoon. I am Ik-han Kim, and I study record information. Thank you for your introduction. I think it was in 2004. Since 2004, I have been involved in designing the systematic laws related to records. And the previous president of Korea made a lot of efforts in this area. And I thought that we were doing well in terms of archiving and recording. But today, listening to your presentations and stories, I come to think that maybe that's not the case. But still, we did make a lot of progress. And still, the lives of each and every adoptee, still, there is so much more that the government has to do. So as an expert in archiving, I came to think that I haven't done much in terms of archives related to adoptees. So with such a mind, I would like to share my discussion. So I want to touch on one of the major ideas and talk about the principles. So generally, when we say adoption records, there are four areas that we need to look into. Today we touched a lot on the information and records. That's one of the core areas. There are many problems in this area. But still, records related to the lives of adoptees is also very, very important. The former is more of a perspective of human rights, but this second element is more about the life of the adoptee. So in each and every country, these adoptees are scattered around in many different countries, and the information or records are also scattered. So we need to collect these in a good way. And third element, along with human rights of the adoptees and establishment of identity and having more social participation, we have many organizations that are moving organically to make changes. So the experience and activities related to these, I think we call them movement records. So how can we collect such information and communicate and make sure that more adoptees participate in such activities and movements? And the last element I want to add, in the 50s till today in Korea, in the past, the authoritative governments were in place, and there have been so many violence by the government. There were many incidents, cruelty brought out by adoption agencies. So these are the past history that we have. So we need to set these past wrongdoings right. So I want to touch on these four elements in terms of adoption archive. And in order to solve these problems, what can we do and how can we do? What efforts can we make? I want to touch on. So regarding the adoption information records, I want to touch on two things. The rest, I think you can look at my discussion paper. So as soon as one is born, the adoptees, the records regarding their life and birth parents, the information and data, they have the rights. They're born with the rights to those information and data. But once they are separated from their birth parents, in that case, the government and society has to take care of that individual. But the access rights to that adoption information, definitely is transferred to the government as well, but this area is the gray area. So the adoption agencies retain information, but these information are not normal at the current state, so these information should be normalized. And in case of adoption information, we call it access control. It's regarding the access to the information, and it's a very sensitive issue. But we're confused in this area that when the adoptee whether the adoptee meets and contacts the birth parent or not, that's an issue of contact. And if the birth parent doesn't want to meet the adoptee, then the contact is difficult. That's fine. But the information related to the birth parent, having access to that information is a different issue. So when the adoptee may have restrictions, legal restrictions, to actually meet and contact the birth parents, but having access to their information is a different issue. And currently, we're simply blocking that access. So we need to legally reform this part. And I don't have enough time, so I think I'm speaking really fast. Apologies for that. And then is the records on the lives of adoptees. This is more easygoing. So how much of these informations, how much communication is there? This is related to the societal identity. And how can we make that more active? In fact, because of such need, there are small communities globally. But we need to make that fit into the network conditions that we have at the moment and upgrade that and create an environment where all adoptees all over the world can communicate better. And another important aspect is that too much is lost already. So we need some kind of movement to find the records of these, the lives of these adoptees, and make that into an asset for the adoptees. The third is the movement records. So there are a few people who are engaged in these movements, and they retain the records related to the movements. But the most fundamental aspect of this is the archive of movements. So the organizations, whatever they do in terms of activities or movements, they need to collect all of those information with the teams and even a more expandatory adoptee information as part of a civil movement. But globally, there are so many adoptees that are already engaged in many different movements. In fact, movement is a conflict between power and authority. And in order to overcome this conflict, we need to create a network using these movements and promote more participation to go beyond authority. In fact, detailed information or knowledge is crucial for movements. Legal or institutional analysis or results of these analysis. There are many organizations hold these analyses, and we need to share this with the general community of adoptees. And lastly, the tragedy of adoption. Again, we need to set right the past history. So we need relative committees. So it's a very, very big hurdle ahead of us.
And let me just read out the script to speed up my presentation. To solve those challenges, I believe that the government should put more budget in establishing the archive, for example, for 3 months. So to establish the platform, of course, including all the birth records as well as the past wrongdoing by the government. So I think that local communities as well as the private sector organizations should be more involved in distributing out the relevant information for establishing the archive, adoption archive. So in this regard, we need to have faster efforts and efforts in establishing adoption archive. And I think that this is really possible based on our technology. So indeed, we also need to look at the ways in which that all the relevant organizations as well as the NCRC can play their roles for the adoption archive. And I think that first of all, we need to have more participation of adoptees in establishing the archive in a more efficient manner. So once we build the adoption archive, so the cost can be paid by the government as well as for other relevant stakeholders, so that we can seek the proactive participation. And the last point is authenticity of the archive. So for the adoption procedures, all the records and documents throughout the adoption, the process is really a big matter of the reliability as well as authenticity. So far, we have looked at a lot of the records and documents, and we have experienced a lot of the limitations from these documents already. And I think that if we ask the government to establish such the systems like the adoption archive, we cannot really prove the authenticity of the records and information, so that we can also deal with those challenges and issues. So in terms of the network or the archive system by the government, we definitely need to specify and its different roles by the government and the private sector as well. For example, if needed, and then we can distribute the copies of the documents and the records upon the request of the government. And absolutely, these information are very important. Absolutely, we also need to see the more active control and the management from the government in establishing the adoption archive. So for you to understand, I'd like to deliver the 3 main points here. Of course, absolutely, these are closely related to the budget of the government, of course. And so far, as I mentioned before, if we look at the records owned and kept by the adoption agencies, still there's a long journey for us to really prove the reliability and authenticity of these information. So first of all, we need to execute these procedures in verifying and proving the information. So to do so, we need to take the prior research and investigation in terms of the number or the quantity of the records and documents by adoption agencies. And the last point is that in terms of the past wrongdoing by the adoption agencies, we also need to look at the progress and the pathway done by the adoption agencies so that we can build a broad spectrum of the platform. And the 5th point is that the suggestions and recommendations for the feasibility in the future. I think that in finding out the roots of adoptees, I think that absolutely we need to put more contributions in making these ideas into action. Of course, once again, we also need to be aware that for adoptees and their social identities and their stabilities and their proactive and positive attitudes into the society, we absolutely need more efforts. Thank you very much for your attention. Thank you, Professor Kim, for your great presentation. Sorry about that, but we have very limited time of today's conference. So now it's the time to have the Q&A session. Due to the limited time, I'd like to apologize that we are only given the time for the 3 questions only. So the first question is the fear of adoption agencies of being sued by individuals whose files are incoherent or and they're being transparent about adoptees' files. Is it their lack of transparency, more about shame or laziness, or general lack of organization or knowledge, or and if adoption agencies' fear of being sued over these incoherent files is removed through some kind of transparency law governing the sharing of adoptees' files, would this incentivize agencies to become more transparent? So I think this question would fit Dave Leap, who can give this answer because I think it's more relevant. And the second question is regarding the process of finding birth families. So digitization of the documents are not sufficient. How can we overcome and improve this situation? And how can we have more access to the information? Again,
think Mr. Dave Reef can give an answer first. And if any of you want to answer, please.
법률적인 어떤 조언, 지원과 관련된 부분입니다. 당연히 이 정도면 뭔가 이렇게 입양인 분들에 대해서 법률적인 어떤 자문을 해주고 이런 것들이 발달됐을 것 같은데 그런 게 보여지지 않는다. 똑똑한 변호사라면 한 사람당 한 $50씩 받고 뭔가 자세히 설명해주고 법을 몰라서 뭔가 당한다든지.
The lawyer can also get some commission fees if adoptees are able to find out their birth families. There could be some of the stories or the cases on the backside. Of course, I think that question can be answered by the lawyer Kang regarding any the practices on the backside in terms of the commission fees between adoption agencies and adoptees. So first of all, David Liu, okay.
Okay, so first of all, I would really welcome the comments from other panelists as well on this, because I can't really say that I know the Korean law well enough to determine whether a lawsuit would be effective in trying to sue the adoption agencies. What I can tell you is that I've heard that something like that has been attempted before and it didn't really go anywhere. I also wonder if the person who asked the question was from America, because that sounds like a very American thing to do. Let's just sue our way to victory. And I think the best frame of reference is, or the best thing to keep in mind is that Korean laws are fundamentally very different as far as what's protected and whose rights and who has the rights. And so to kind of systematically apply maybe a Western thought as to like, well, this should work, I think poses different challenges as far as understanding how things actually work here in Korea.
Regarding the first and second questions, if you have any comments, please, hands.
네, 일단 없으시면
Okay.
세 번째 질문 답변 드리겠습니다.
So the answer to the third question. So regarding the first question, why are adoption agencies not transparent? Because I think it's the responsibility of the government. So we need to look from the government's perspective. So why did they simply leave these agencies do whatever wanted to do? And the question on the lack of legal institutions, I don't think it's an issue of money. I think we need more interest in adoption and adoptees. And basically, lawyers have the obligation to do public duty. So lawyers, again, have to have more interest in these issues. And from the Ministry of Health and Welfare, she explained about the adoption information disclosure system, and there are many people out there who don't know about this system, so we need to inform people to know more about this.
Okay. Regarding the three questions, I don't really think that all the answers would really completely answer those questions fully. But by listening to other presentations, are there anyone who really like to propose any idea, just very briefly due to the limited time? Okay. If there is none, then I think that it's the time to wrap up my response. Okay, David Roop? Okay. Professor Alice Diber, do you have any comments?
I think on the issue of suing adoption agencies, that would be wonderful. I think that would be great, and possibly that will be the future. I'll be first in line. I think that difficulties attach, I mean, it's hard enough to even get an apology. I'm thinking of Ireland and the church. I'm thinking of the baby scoops with Indigenous peoples in Canada in the 60s. It's hard enough to get recognition. I think societal change is needed. I had to tell a student off a few weeks ago. They were using the classic insult of, oh, you must be adopted. She picked the wrong class to say that in. To my shame, I got a little bit angry. I said, why do you think that's funny? You know, and how, so she won't do, I was nice, but I don't think she'll make that mistake again. So I think there's a lot of aspects underpinning legal change. The law is quite adult centric. You know, I think child rights will always be outbalanced. Privacy will win because it's cheap. You know, I'm not saying that change will never come about, but I think we're still a little bit away. But we'll keep at them. You know, we'll gradually we will wear down the powers that be. I think. You know, those are my thoughts.
Thank you very much. Thank you very much for your.
Thank you, Mr. Huang, and thank you again to all presenters and panelists. I think we ran for about 3 to 4 hours. Despite the difficult circumstances in an unfamiliar format, we have concentrated on this conference and shared thoughtful discussions and opinions. And lastly, we have a closing remark. Actually, Professor Bunyoung Han was to deliver the remarks, but she couldn't make it here today. So I want to hand over the mic to Jenny Na, who has been introducing the panelists today.
Thank you. So as you just heard, I've been asked to give the closing remarks written by Bunyoung Han, who is called away on business and cannot give them herself. Bunyoung is an assistant professor at Hankuk University of Foreign Studies and a member of the planning committee that organized the conference and wrote the Adoption Tuesday Declaration. Here are her closing remarks. We have reached the end of the first Adoption Tuesday International Conference, and it is my task, on behalf of the conference organizers, to provide some closing remarks. While it is sad to close the door on our conference today, it's been a unique experience to work with everybody, friends and colleagues from around the world, in preparing for this. 2020 has been a challenging year for everyone. And even today, we find ourselves unexpectedly separated across borders. So a special thank you to our keynote speaker and presenters based outside South Korea, in Europe and North America, who have taken the time and effort to contribute their analysis of the adoption experience and the legal framework pertaining to this experience. We've heard testimonies from those most directly impacted by the adoption program, placed domestically as well as overseas. Under the theme, Adoption Justice, Issues of Records and Identity, our presenters have identified and spoken about a child welfare program characterized by a systematic failure to protect children and their families. Our presenters have shared their experiences of switched identities, unclear methods of relinquishment, and an absolute erasure of origins. The adoption discourse is evolving as we learn more about the lifelong consequences of the adoption program, and we consider adoption truths to be an invaluable aspect of this. We have a vision of justice and protection of basic human rights for those impacted by the adoption program. One we can only achieve together. Finally, I hope you found inspiration in today's contributions for your future adoption-related work. Thank you for your participation, and we very much hope to see you in 2021 for further discussion on the issue of adoption truths. Thank you. 감사합니다.
Thank you. For the past 9 years, though we have commemorated the Single Moms Day, but from this year, we have been starting to commemorate Adoption Truth Day to more congratulate the opening of today's conference and the Adoption Truth Day. Absolutely, we will put our continued efforts and energy with the stakeholders and the relevant organizations. By taking these opportunities, the lawmaker Jung, Choi, Seo, as well as the Kang, from the Democratic Party of the Korea, my special thanks also go to all the lawmakers for today. And I really sincerely hope all of you, the efforts and the participation. And in addition, I'd like to also express my gratitude to Aki Korea and the Family for Every Child for your dedication and sponsorship as well. And also I'd like to especially thank all the speakers and the presenters and also hosts for today's conference. Now, from the beginning of today's conference, we have reached about the 210 participants joining on the online platform. Now, still, we have seen a lot of the participants until the end of today's conference. So, taking this opportunity once again, I'd like to really appreciate all of your participation for long hours. And the conference today will be available on YouTube channel later once we finish our editing on the video. To all speakers and the panelists and moderators and participants for today's conference, and now you are seeing the screen all together to show the faces of all the participants today. And let me also invite and introduce all our representatives for today's conference on the stage. Okay, so please share your screen to show your faces. I did not really realize that there are so many participants joining today's conference. Thank you very much for sharing and showing your faces. Thank you. Thank you very much for a lot of the participation for long hours. Thank you very much for your attention. Can you also wave your hands to say goodbye? Thank you very much for your efforts and dedication today for long hours. So let us announce the closing of today's conference, the first Adoption Truth Day International Conference on the topic of the adoption justice, issues of records and identity. We're also going to hand out the survey and a questionnaire. So please fill in the survey and the questionnaire regarding the programs of the conference. So please fill in the survey, the sheet, and then reply to us as you can. And I think that thanks to your all dedication and participation, and for a very happy life and very enjoying life, I really wish you health and success in the future. Thank you.